We're live on TV3 Ghana on Facebook, as well as DSTV channel 279 all across the world on 3news.com. Stay with me. I'm going to walk you through the chronicling of events about the former member of parliament, at least per the Supreme Court ruling today, James Jachikwason. This is Ghana Briefs. The International Monetary Fund has approved Ghana's $3 billion extended credit facility and would hold a news conference tomorrow, Thursday, May 18, to provide insights into the outcomes of its executive board meeting. The first tranche of $600 million from the International Monetary Fund for Ghana is expected to hit account of the Bank of Ghana this week. The director of the Institute of Statistical, Social and Economic Research, ISE, at the University of Ghana, Legon, Professor Peter Korte, has lauded government's efforts at securing an International Monetary Fund bailout program. Ghana has received IMF board approval ahead of other countries like Benin, Indonesia, amongst others. Professor Peter Korte cautioned government against a return to the capital market.
We should reduce our tests for capital market funding because they're expensive. They don't come cheap. We should look more into getting concessional loans. We should look more into growing our economy so that we can get more foreign exchange from exports.
The minority in Parliament has described as a slap in the face of democracy and the rule of law the decision by the Supreme Court for the House to expunge the name of Asin North Member of Parliament James Jachikwason from its records. Minority Leader Dr. Kesela Toforsen stressed that Jachikwason was not a dual citizen as at the time of election and taking the oath of office into the 8th Parliament. The Public Utilities Regulatory Commission has justified an 18% increment in electricity tariffs effective June 1. According to the Commission, this, amongst other things, is to recover a 25% loss in the first quarter adjustment.
We had already a loss from the previous tariff that we did. We did only 75% of the exchange rate. Thus, we had a 25% under recovery that we need to recover. So if you add all this to it, the exchange rate we use currently now, which is the projected exchange rate, is 12 cedi 71 pesos. That's what we are using. So all these factors combined led to an adjustment of the tariff.
Good afternoon. Are you in high spirits?
My spirit?
Yeah.
Well, I cannot actually comment on any matter that is in the courts. But I can tell you I'm in a very high spirit.
Do you have any word for your constituents?
No, they know what I'm doing here. My constituents speak for themselves.
Okay. After 3 years of a long, winding battle from the High Courts to the Supreme Court, it appears Jachikwason may not be allowed into the presence of the legislature with that express order from the Supreme Court.
That's how things have played out until today, that the Supreme Court has given that ruling that the name of James Jachikwason should actually be expunged from the records of Parliament. Now, if you look at the Constitution, Article 94(2)(a) is where a lot of this concerns that were raised about James Jachikwason and the basis for this particular case in the first place. A person shall not be qualified to be a member of Parliament if he owes allegiance to a country other than Ghana. In this case, James Jachikwason, according to the gentleman who petitioned the Supreme Court, in fact, the High Court first to look into this matter, said he held a Canadian citizenship at the time of filing his nomination. That was the basis for this. And if you recall, just last week, this article was an article of reference for both John Mahama and then also Henry Nana Boakye of the NPP, that both of them want to have a review of this particular constitutional provision done, or an amendment of it, because they say that this discriminates against persons from the diaspora who want to come in to contribute to the development of this country. We'll see how all of this ends. But there are a few questions that we are asking tonight. After this ruling, what next? does this ruling take retrospective effect? As in that if his name is supposed to be expunged from the records of Parliament, does it affect every decision that he was part of in this 8th Parliament, including, for instance, the election of the Speaker of Parliament and so on? Can he be referred to as a former MP of Asin North? Because essentially what the Supreme Court is saying is that the election itself at Asin North in 2020, December 7, is null and void. It didn't happen. So can he contest a by-election if Parliament eventually communicates the vacancy of this particular constituency to the Electoral Commission? What's next for him? Stay with us. That's why we're going to get a lawyer joining us on Ghana Tonight. James Jachekwason has issued a statement. He says he's disappointed by the court's decision, especially surprised that the court now says that foreign bureaucrats now determine whether natural-born Ghanaians have the right to contest for parliamentary elections in Ghana or not. It goes on and on. In fact, he's went to say that thus the country does not allow renunciation of its citizenship can bar a natural-born Ghanaian who has several or all relations with a country of acquired citizenship. Now, if you look at this and how this case has traveled over the period, this is how it all started. If you recall, in December 2020, when the polls, that's 2020 elections, James Jachekwason was elected as Asin North Member of Parliament. Then that same period, right after the elections, one Michael Ankoma Nifa petitioned the High Court about that dual citizenship. Michael Ankoma Nifa alleged that James Jachekwason was a dual citizen at the time of filing his nomination. That is the Canadian citizenship, which eventually we got to know that he received his renunciation certificate. Eventually, what's happened now, from at least what we have seen, is March 2022, the Court of Appeal then struck out appeals that was indeed filed by James Jachekwason. The Supreme Court then restrained the Asin North Member of Parliament in May, that's April 2022. The case has traveled a path over the period till now. When there was an injunction that the Supreme Court granted, these were the judges who sat on that particular case. In fact, there was a 5-2 ruling on that injunction, which indeed the decision was that he should not hold himself as a member of Parliament. This is it. Justice Jones Doche, Justice Mariama Owusu, Justice Gertrude Tokono, Justice Professor Henrietta Bonsu, and Justice Emmanuel Yonikolendi, they ruled indeed that 5-2 decision upholding that injunction application against James Jachekwason. This was sometime in April 13, 2022. This is when this injunction was granted, just a little over a year ago. Those who dissented, the two judges who dissented with respect to this injunction was Justice Agnes Doji and Justice Nene Amegache. So this one is with respect to that injunction application that eventually had James Jachekwason not being able to perform his parliamentary duties as a member of Parliament for the Asin North constituency. Over time, the decision by the Supreme Court today is what now has put the final nail to the coffin. So we're going to be asking and answering these questions right after this quick break. Justice Shremsai is my guest on Ghana Tonight. What does this really mean? Coming up next, right after this quick break, we'll answer all these questions for you. Stay with us. Well, welcome back. This is Ghana Tonight. Now, the Supreme Court has, by a unanimous decision, ordered the Parliament to expunge the name of James Jachekwason as Member of Parliament for the Asin North constituency. Now, the ruling by the 7-member panel bars James Jachakwason from holding himself as a Member of Parliament. And this we saw playing out in very interesting ways. Now, in November, if you recall, November 2020, a group calling itself Concerned Citizens of Asin North petitioned the Electoral Commission to withdraw the candidate of James Jachakwason, arguing that he owes allegiance to Canada. Then, in December, eventually a resident of Asin Breku in the Central Region, on Michael Ankoma Nifa, subsequently filed a petition at the Cape Coast High Court after the election, seeking to annul the declaration of James Jachakwason as the Member of Parliament, as I showed you in there. Now, the case has traveled from that period up until now, and how things are indeed looking. And we're asking specific questions tonight, especially because after the ruling, questions were raised that if his name has to be expunged from the records of Parliament, will they take retrospective effect? Dr. Justice Shremsai is a senior lecturer at the Gimpa Faculty of Law. He's joining us on Zoom. Dr. Shremsai, thank you so much for joining us on Ghana Tonight. I want to first of all start off this conversation taking into consideration all the divergent views and opinions that have been raised about this particular one, especially on the implications of it. Now, what will be the legal implication of this ruling? I mean, that Parliament should expunge the name of James Jachakwason from its records.
Well, the implication of the decision is that he ceases immediately to be a member of Parliament. That is what it means. He can no longer sit in Parliament. He can no longer debate in Parliament. He can no longer vote. He can no longer, he's no longer entitled to all the privileges and the right that MPs are entitled to. So all of them are extinguished immediately.
I see. Now, will this affect, for instance, that decision that for instance, the other decisions he took in Parliament? As in, people have made reference to the typical one, what happened on the night of January 6th into January 7th, the election of the Speaker. If you recall, even prior to that, as to whether he was even going to be allowed into the chamber, because at the time there was that court case already in motion, but he could not be found to be served. Now, if this has to be done, will the expansion of his name take retrospective effect in terms of every decision that he took part in Parliament?
No, the Constitution, contemplated situations like this. And so there is a specific provision which takes care of this situation and makes it so according to the Constitution, a person who took part in the proceedings of Parliament or has been performing parliamentary functions, who is not entitled to or who was not qualified, yes, the person may stop being a member of Parliament, but it does not affect any decision or any processes that the person has taken part in previously. So in this case, there is no way that the previous decisions or actions that were taken by this Parliament, which the honourable member, participated in, would be nullified or would be affected. The decisions and the votes and all the processes that he took part in are still valid and will bind as though he was qualified when he took those decisions. Yeah. So the decision, as you are aware, we do not know the reasoning that went into the decision, but it's very important for us to examine. The journey of this case is quite interesting, and I think that it still leaves a lot of questions to be answered. Perhaps we may find answers to some of these questions in the decision when it is finally released. But there are certain things that we are already aware of. So Mr. Kweson's he held a Canadian and Ghanaian citizenship at the same time. He was a dual citizen at the time, that is in 2019. And according to him, he filed a renunciation. He renounced his Canadian citizens in 2019 December. Then he filed his nomination in October 2020. That's almost a year after he put in his application for renunciation. Now, the certificate for renunciation was not issued until after he filed his nomination, which was in November 2020. Now, he got elected in December 2020, and then the petition was brought against him in December, 30th December 2020. Now, the petition is specifically saying that, yes, even though he, at the time of election, did not hold a dual citizenship, he was disqualified he was disqualified because he held, or the certificate of renunciation was not issued when he filed his nomination in October 2020. Now, the key question that we expect the decision to answer is, at what point in time do we say that do we look at the eligibility or the qualification of a person to become an MP? Because the Constitution was specific in saying that you cannot be an MP when you owe allegiance. In other words, in this case, when you have dual citizenship, you cannot be an MP. Now, before the election, so at what point in time do we say that a person is qualified? Do we look at the qualification? Is it when nomination is closed? Is it when the person is filing the nomination? Is it when the election is going on? Is it before he took his oath in Parliament? So these are all possible timelines which the court could put the line, or the line for determining when the person is really qualified. So, for example, we expect that the decision will give us an idea of what time should be taken as what we call, lawyers call the critical time for determining qualification. Now, there are other issues that need to be considered, because the Constitution itself does not provide a time for nomination. All it says is that parliamentary elections should be held within 30 days before the dissolution of Parliament. So it means that between December 6th and then January 6th, we should have held the election. That is how come we end up having the election on December 7th. Now, one argument is that date of December 7th should be the critical day for determining whether the person is qualified. Another argument is that, well, it's the EC that determines. Now, when the EC is determining, can the EC, for example, put the date for nomination in January of the year in which the election to be held, making it so, in other words, the EC can say, well, if you don't file your nomination in January, so can we put the critical line or the critical timeline for determining qualification in the hand of the EC? So these are some of the questions that we expect to see answered in the decision, which is yet to be released.
You've answered the first question that we put up earlier, that this is not going to take retrospective effect, right? The second issue that we want to look at now is the specific decisions that we're taking. If Parliament has to now go by the Supreme Court's directive, expunge his name from your records, what will be the implication with respect to the Parliament's own work and rulings and decisions that have been taken?
The effect of the decision is that he was never an MP. So, yeah, of course, people can refer to him by whatever description, but I think the point is that once his name is expunged from the record, it's as if he was never elected. And in fact, that is the meaning of, because it's about the constitutionality. The court was exercising its Article 2 jurisdiction, which was determining the constitutionality of an act or a behavior. And once the behavior is declared unconstitutional, or his eligibility was nullified based on grounds of constitutionality, it is as if he was never elected. It was as if he never filed a nomination. It's as if he never sat in Parliament. So, properly speaking, he will definitely not be accorded a status of an MP. And that also means that if he has already taken emolument, I don't know how they are going to recover it. But definitely he will not be given the award that are usually given to ex-MPs, since his election is deemed as never, to have never happened.
So in this context, even from what you mentioned earlier, he cannot be referred to as former member of parliament for Asin North? I mean, because if what you've explained that the impact of this ruling is that the election never took place, that's it.
Media journalists are doing they are basically communicating, they are giving information to the public. So if you choose to, for purpose of identification or for purpose of describing the person, and you indicate that he was the former MP of this, I don't think there's any real legal implication or consequence for such description. I mean, lawyers don't really do much about words. I mean, we don't care about how things are described. We care about what the legal effect. So if a journalist says it was a former MP, it has no legal effect. It's just a purpose of providing information to the public and describing the person. So I don't think that there will be any legal consequence for such, casual description of the person. However, if beyond the description or beyond the nomenclature, someone seeks to have some actual legal consequence of that, or seeks to, for example, say that he's going to probably take ex gratia, or he seeks to use the office as maybe some immunity, or to retain some property or something, then clearly that will be will have legal consequence. But I don't think that journalists or even the public describing him as such would have any legal
implications. I see, but take us through the processes. I mean, now, for what's going to happen is that if this Asin North election on December 7, 2020 has been declared null and void, then eventually there has to be a by-election. So what's going to be the process before the by-election actually takes place?
Yes, so the Constitution spells out the timeline for a by-election in such circumstance. And the provision is that once the seat is declared vacant, that is today, at least we are aware that the Supreme Court has made that declaration that the seat is vacant. Now, in terms of legal practice, what will happen is that the plaintiff or the applicant would have to apply to the court registry for the order that the court made to be drawn up. Once the order is drawn up, perhaps the registrar is under administrative duty to communicate the decision of the courts in the form of the order to the Speaker or the Clerk of Parliament. Once the clerk receives that, we can now say that the clerk is officially aware that the seat has been declared vacant. And when that happens, the clerk has 7 days, within 7 days, to communicate the vacancy to the Electoral Commission. Now, once the Electoral Commission receives the communication, it has 30 days within which to organize the by-election for the vacancy to be filled up. So this is the timeline for the process. So in other words, we are in May. So we should expect that by the end of June, there should be we should be expecting a by-election in the constituency.
Now, and the last question, and these are the questions that we said we're going to get answers to. We put out on the screen right now. These, with the clarification that you've given to us, we have clarity to the first two. Now, can he contest the Asin North by-election based on the indication you're giving to us and the constitutional process, that eventually the Speaker will have to communicate this to the Electoral Commission that the Asin North constituency seat is vacant, and so there has to be a by-election. Now he has received his renunciation certificate from Canada, so he holds no allegiance to Canada, so there is no dual citizenship matter. Can he contest this by-election?
Well, I mean, the decision or the case in court is simply that the time he was filing the nomination, he owed allegiance to another country. Now, the evidence from the court, if you read the High Court decision, it was clear that he wasn't even having dual citizenship at the time of the election, because his certificate was issued somewhere in November of 2020. That is 1 month before the actual election. And so from November 2020, he did not have dual citizenship. So what it means is that he is now eligible. In other words, let me be careful what I say. He cannot be disqualified from running for another election on grounds that he owes allegiance, unless, of course, there's new evidence that he owes some other form of allegiance, or that any of the other disqualifying factors apply to him. But if we are talking of this specific fact of the Canadian citizenship and what led to his removal from Parliament, we can say that that situation is no longer, and therefore he would proceed to he is eligible to contest on that ground. Now let's look at it from another perspective. There is also a crime. There is a crime which there's a law which says that a person who knowingly, I think the key word is knowingly, puts himself in Parliament. I mean, knowing that he is not qualified, puts himself in Parliament, has committed an offense. Now, the key word here is, so perhaps maybe the Attorney General would give an advice on this, whether they will go ahead to conduct a prosecution. Now, the key word here is knowingly, from the facts that we saw in the High Court case. And of course, that is not a criminal trial, so we cannot, stick to those facts. It appears he did not do that knowingly, because from the fact, he actually, informed the Electoral Commission of the situation and relied on the Electoral Commission's, assurance and clearance in contesting. So I think that will bring a bit of a twist to it, whether he knowingly put himself in that position. But there's a crime for persons who knowingly put themselves in Parliament, when they are not indeed qualified. So it's a question to be answered whether the Attorney General will proceed to the fact that to prosecute him, and indeed the fact that you start prosecution does not necessarily mean that you are going to secure conviction. Now, the other question to be asking is that would he, for example, be the fact that you started prosecuting him, does that make him not eligible? Obviously not. That is innocent until what? Proven guilty. So between now and the by-election, unless there is a conviction, which in turn will now disqualify him, because when you are convicted of an electoral fraud or electoral crime, whatever, it also disqualifies you from contesting, in subsequent election up to some period of time. So here we still have to wait to see what the Attorney General would want to do with the situation. But for now, I think that for all the factors that we know and the factors that are under consideration or discussion, nothing prevents him from picking up nomination and contesting again in the same election for the same constituency.
Very interesting explanation, and also that clarity you bring to the position of the law on this matter. The coming days will be one to watch. Dr. Justice Shremsai, thank you so much for joining us here on Ghana Tonight. He's a senior lecturer at the GIMPA Faculty of Law, helping us on this. But this is Ghana Tonight. We went to the Asin North constituency. Some of the constituents there had their own thoughts about the Supreme Court ruling today, which essentially renders them orphans. There is no MP for them in Asin North constituency. Take a look.
The things that he has done for his constituents, putting people into apprenticeship, a whole lot. So, in fact, with the ruling that has come today, it is very unfortunate, and that person who took this issue to court has done a very great disservice to the people of us.
We are not happy with what has happened. The man didn't commit any offense. So why should he be prevented? If so, then we will not vote for anyone here.
A constituency without an MP does not develop. We clearly lack a lot of things because we have no MP. This is unfair.
I'm learning this trade because the MP employed us for free. With this good gesture he has shown, why would they want to remove him as MP?
In the Asin North constituency. This is Ghana Tonight. Up next, the International Monetary Fund has approved, as the board has approved, Ghana's $3 billion extended credit facility. And what we are seeing now, there's going to be a news conference tomorrow to provide insight into the outcomes of the executive board meeting. Now, that's coming up next. Well, we understand that the first tranche of this $600 million from the IMF for Ghana is expected to hit the account of the Bank of Ghana this week. Abdul Sani Rahman is my colleague. He's joining us from the United States. He's been monitoring what's happening in Washington, D.C. ahead of tomorrow. Sani, thank you so much for connecting with us on Ghana tonight. What more have you gathered beyond the announcement of the IMF board's approval of our $3 billion extended credit facility?
Well, Alfred, the conversation has moved from the excitement that greeted the announcement of the $3 billion bailout for Ghana and to the details in the approved program. We are beginning to learn some of the conditions that will kind of walk the program in its 3-year lifespan. We are learning that the disbursement of the first tranche is immediate. So as you indicated rightly, sometime this week or early next week, the Bank of Ghana should be receiving the money on behalf of government. But we are getting to know that government will have to do a lot in order to sustain the program, and that will kind of ensure the country receives the rest of the 5 tranches. And that is where I think the focus of the nation should be. That is where the focus of managers of the economy should be. And let's not put too much energy on fanfare to celebrate what appears to be victory for players in the economy. I'm referring to managers of the economy because there is massive work ahead of us to do. And if we do not get to do that successfully, the implementation of the program would be jeopardized. Key among these conditions has been the successful completion of the debt exchange program. We are aware the external creditors have given financing assurances, and that is only the first step towards debt restructuring. And that is just to give an indication to the fund that we are committed to providing some sort of debt relief to the struggling country, Ghana. But in the meantime, you can go ahead to grant the loan that will help restore macroeconomic stability to avoid the economy from crashing. Because once the economy reaches that level, the managers of the economy will not be in the capacity to even raise enough funds to pay the debt. So they are asking that the government should begin quickly engaging the creditors and get to know what sort of relief that they can provide us. Will the reliefs be in sync with the expected fiscal targets of the IMF? If it's not, then there is a problem, as we have seen in the case of Zambia and the rest of the countries where creditors have given financing assurances, but negotiation as to how the debt restructuring should be done have become a major challenge, and that is threatening the implementation and the release of the remainder of the funds agreed with the International Monetary Fund.
I see. Now, Sani, you are in the U.S. Right from the IMF spring meeting, which you were there, you covered it, you stayed up, you're still monitoring happenings there in the United States. Now, if you listen to the IMF's pronouncements, and then also today, I know while you're there, you've also been watching how things are playing out in Washington, D.C. ahead of tomorrow. What is the body language of the IMF really communicating to you as per your interactions today in the U.S.?
Well, I've seen a shift from the language initially used by the managing director, Kristalina Georgieva, and that is the first point I want to make here, because we've heard in the past, even during the spring meetings, numerous occasions she has indicated that the challenges in Accra has largely been as a result of the twin events that we've seen around the world, i.e. COVID-19 pandemic, which has devastated economies around the world, and of course the Russian invasion of Ukraine, which has caused energy prices to rise so fast around the world. But today, in the statement, and of course, even in the tweets, we've seen by the managing director, she has indicated that there were pre-existing vulnerabilities. And that is what a lot of analysts have been talking about, that the challenges the economy has faced has not only been as a result of the Russian invasion of Ukraine and, of course, the COVID-19 pandemic, because the Article 4 review in 2019 by the IMF indicated that there were signs of fiscal stress and the government had to do something about the debt accumulation. The government had to do something about revenue generation and a lot of more or less recommendations that the IMF made. But at the height of the issue, we saw a bit of diplomacy on the part of the managing director, trying to water down the concerns that governments more or less reckless borrowing and expenditure have partly contributed to the challenges. But today we've heard from her, and she's indicating that there were some pre-existing vulnerabilities, and that's an admission that there were challenges on the part of the managers of the economy as to how they were running the economy, and the causes of the event were not just because of the twin events that we have seen around the world. And that is the indication that they are coming to reality and pointing to the government that those existing vulnerabilities must be dealt with, and they have clearly spelled out that in the statement.
Sunny, stay with me. Now, Professor John Gachi is the Dean of the University of Cape Coast Business School. He's also joining us on Zoom. Prof, so after this IMF board approval, then what next? I mean, we're hearing the money coming in tranches. What's the process?
Well, after the board approval, we now wait for disbursement of the monies, and then other technical engagement with the government of Ghana in the management of the economy. That is what we await. We were told that $600 million will be released very quickly. And after that, performance benchmark will be adhered to. That will trigger the release of further tranches going forward. But tomorrow, there will be a joint press conference of the IMF and the government of Ghana, represented by the finance minister and the governor of the Bank of Ghana. And that press conference will make things clear to all of us as to whether there is some other conditions precedent to the disbursements of the first tranche or not. So those are the things we are waiting for. And I must indicate that this is just the first leg of the engagement. This is now giving the IMF the authority to lend to Ghana and the authority to engage more than just mere membership activities that they have been doing that culminate in Article 4 consultative report. So now it gives the IMF a further mandate to watch over the economy of Ghana.
Right.
So that is where we are now.
Talking about the watching over the economy of Ghana, I mean, there's been proposals that Parliament should consider a law to cap or put a ceiling on the amount of money government can borrow or in the name and of the Republic of Ghana and on our behalf. Reason being that even before this money comes in and the $3 billion extended credit facility gives us some credibility, ministers of state have been quoted as saying that if this deal is approved, it will be an opportunity for Ghana to go back to the capital market to continue borrowing. The same sin that brought us to this point. So can that be considered?
Well, that is welcome, but that will not be the solution for our debt appetite. We have to demonstrate leadership that is aware of prudence management, that is aware that Ghana has a certain debt to GDP level. When we cross that level, it poses challenges for us. That respect for fiscal indicators is not part of our leadership style. That is why we are facing this problem. Various institutions such as Parliament, knowing very well that these indicators have meaning for our economy, go ahead even in times where the debt to GDP crosses a certain mark, approve huge sum of money for the government in terms of allowing government to go and borrow. So the first thing is that we need to groom leadership that have respect for financial prudence. And then when we bring that law, then we will respect the law.
But at least there's evidence that any time we're under an IMF program, government has no choice than to be fiscally disciplined. They can't be as reckless as we were outside of the IMF program, is it not?
That is the general expectation. But don't forget that the IMF was with us in 2017, 2018. They basically allow government to roll out every funny agenda. We have NAPCO was rolled out, and all those things were rolled out. All the borrowings were happening under the IMF watch. So I don't know whether the IMF will be any different this time around, because they have proven that they were not effective in ensuring that governments stick to fiscal indicators. So as to whether they will do that this time, I can't really tell.
Now, Professor Kachi, I'm going to come back to you for the final question, but please stay with me. Sunny, now, before I let you go, we understand already some government officials have arrived in the U.S. Where you are ahead of the official announcement tomorrow. Tell me what you've been picking up.
We know Finance Minister Ken Ofori-Atta himself, Governor of the Central Bank, Dr. Asin, and some officials from the Finance Ministry have been in Washington for a while now, trying to seal the deal, and they have done just that. Ordinarily, we've seen in some cases the statements by the IMF announcing the program should be enough. Any sort of other engagement should be done in Accra, but they have chosen to have a joint presser with the mission chief here in Washington. And I clearly understand the rationale behind such a move, because they want to take advantage and do some sort of market signaling. They are in a haste to restore investor confidence, because lack of that has resulted in the mass exodus we've seen on the markets. For example, on the fixed income markets, we've seen a massive sell-off, and that's as a result of a weak investor confidence that the economy has suffered. So they will want to take advantage of this good news and signal to the market that they are on the right path, they are about recovering, and they will want them to return and do business with the economy. So not much expected tomorrow, just an engagement with the media, and get also to provide also an opportunity for the media to ask some sort of questions regarding the program and how they intend to seal the debt restructuring with the external creditors. Also the domestic front, we haven't entirely completed the domestic debt exchange program. We have the outstanding cocoa bills. We have the domestic dollar bonds that government is still trying to work on. We also have outstanding engagement with the labor front, because government is trying to look at how labor would also come into the picture to support the government debt management strategy. As to how government intends to do that, whether labor would be roped in to the debts restructuring, that's another conversation, because they have vehemently denied that. So not much expected from Washington tomorrow. A normal event for them to announce and provide an opportunity for the media to ask questions. But we certainly get to know more as to how the parameters of the program and what will guide the successful implementation of the program would entail.
I see. Sani, appreciate you as always, and thank you very much for connecting with us live from Washington, D.C. Abdul Sani Rahman is my colleague, monitoring happenings live from Washington, D.C., where tomorrow we're expecting that official announcement. Stay with us here on TV3. We'll bring you the details as it unfolds. But Professor Gachi, before I let you go finally, the Ghanaian people still have to pay the price somehow for this $3 billion deal that we've gotten, is it not? We're seeing this increase in electricity tariffs. It certainly has something to do with the IMF program, doesn't it?
Well, seeing them, we need to pay economic price for services delivered from the utilities. So that is why we have seen PURC inching up its tariffs. That will be a freeze on employment, except for critical areas such as health, education, security services. But generally, there will be maintenance of the conditions relating to freeze on employment. Then the enhancement of taxes we pay have been deployed already, and more may come in the coming months or years. So those things are the price that we have to pay.
Professor Gachi, thank you so much for your time. Professor John Gachi is the Dean of the University of Cape Coast Business School, and talk about the prices that the Ghanaian people have to pay for this IMF deal with the increases in the tariffs. That's one of it, because the PRC earlier today justified the 18% increment in electricity tariffs effective June 1. According to the Commission, this, among other things, is to recover a 25% loss in the first quarter adjustment. Take a look.
It's the second time electricity tariffs are going up in the year, following a new mechanism of a quarterly review. The Q2 review has announced an 18.36% increase in electricity tariff, representing an 11.33% reduction in the first quarter figure. The PRC, in a statement, explains that this decision was taken to balance the prevention of extended power outages and their adverse implications on jobs and livelihoods, while minimizing the impact of rate increases on consumers. The increment is across board, certainly not going down well with some consumers.
Already things have been tough, economically, going to the market, buying foodstuffs, everything has been increased. And so increasing tariffs at this point in time, I think, is just not the best idea. Because if anything, the government should be thinking about the layman, the people that do not even really have much work to do, but yet they are charged to pay utility bills, water bills, prepaid, and all of that. So it's a huge challenge on the economy in itself.
Now the economy is very hard and things are very bad. Thinking of income, because at time you work, at the end of the month, you are taking, let's say, 400 cedis at the month, and now electricity bill will come, let's say, 300, 400. How much are you going to spend on yourself and the electricity bill? So it will cost a whole lot on we the youth.
The utility regulator says it considered factors including the CD-dollar exchange rate, inflation, electricity generation mix, and the weighted average cost of natural gas.
We had already a loss from the previous tariff that we did. We did only 75% of the exchange rate. Thus, we had a 25% under recovery that we need to recover. So if you add all this to it, the exchange rate we use currently now, which is the projected exchange rate, is 12 cedi 71 pesos. That's what we are using. So all these factors combined led to an adjustment of the tariff in an upward.
But organized labor has also kicked against the tariff increases.
We will look at the conditions of our people, the real amount of money we have as a nation, the real income, salaries and all that, and then we'll take a decision accordingly. Well, we haven't come full circle yet. Today is the announcement on one utility. Tomorrow will be announcement of another, and at the end of the day, we'll aggregate all and know where we've come to. But the political class have sold the people of this country. The political class have been very irresponsible, and they've brought us to where we find ourselves.
Government should be ready to actually find, if you look for some money somewhere, to see how best to help workers take care of these variables. At the time you went into the negotiation, you were paying certain amount, or you were certain amount of your salary going into utilities. Less than 5 months, it has been increased by more than 30%. What do? Where do you get money to take care of those bills?
The PURC has also been responding to reports that the tariff increment is part of the IMF conditionalities.
The Commission is supposed by its mandate to do a quarterly tariff review. And that quarterly tariff review is on a 3-month basis. So we are just doing our work. If it feeds into the IMF conditionalities, that's fine. But we are mandated to do a quarterly tariff adjustment. So that's what we've just done.
With the new tariffs, residential consumers who paid 1 cedi 15 pesos will now pay 1 cedi 36 pesos per unit of power, whereas non-residential customers who paid 10 cedis 8 pesos will now pay 12 cedis 8 pesos. Grace Hamwa Ajuman, TV3 News, Accra.
When you go onto the PRC's website, you get to see the brackets of consumption that you fall in. You calculate the 18%, but that's the reality, the increasing cost of living. And that's one of the impacts of this IMF program and some of, as John Gatti said, the prices that you and I as citizens will have to pay for this. Stay with us. Tomorrow at 2:30 p.m., there's going to be a joint press conference to announce the details of this IMF program. Definitely will subject it to a lot of conversation here on Ghana Tonight and our various bulletins as well on TV3. On behalf of the rest of the team, thank you so much for staying with us on Ghana Tonight.